White, also from Orange County, and Joshua Mize from Orange County. The first case on our docket is 23-80, Charles H. Curlin versus Kathleen A. Gallagher Curlin. Are counsel ready to proceed?
Good morning, Your Honors.
Good morning.
My name is Allison Perry, and I represent the appellant, the former husband, Charles Curlin, in this matter, and I'd like to reserve 5 minutes for rebuttal, if I may.
Ready for reserve. You may proceed.
Okay. This case involves a prenuptial agreement where the trial court did not effectuate the intent of the parties' prenuptial agreement, which the stated intent was if there was a divorce, the net assets of each party would be returned to that party and any excess would be split evenly. The trial court did not follow this directive and instead followed the rest of the agreement. And did you have a question?
Yeah, did anyone have a question? No. No, you may proceed.
I'm sorry, it's cutting in and out. Importantly, the paragraph that's important is paragraph 29 of the prenuptial agreement, which states, notwithstanding anything to the contrary herein, the parties intend that the economic effects of this agreement shall be that if a divorce subsequent to their marriage were to happen, the net assets value of each party would be returned to that party and any and all excess will be split evenly.
Would you agree that that paragraph is general in nature, or there are more specific paragraphs that say where certain properties should go?
Yes.
Yeah.
There were paragraphs that stated where the property should go. However, the notwithstanding anything to the contrary herein language trumps is the operative paragraph that says what the intent of the parties are and what should be controlling when there's conflict.
Counsel, in reading your brief, I understood your argument that you say, hey, we have these paragraphs addressing the specific assets, but we have a trump paragraph. It says it's a trump paragraph, notwithstanding foregoing. Notwithstanding that you think the contrary of those prior paragraphs, you have to follow paragraph 29. But I wasn't quite clear on, in looking at your brief, you would quote the paragraph and say that the parties were supposed to have their net asset value. And then your brief would say, thus they agreed they would leave with their net worths. And there seemed to me to be a step missing in the analysis because the paragraph doesn't say net worth. And that's a pretty common term and we all know what it means. It says net asset value. And I wasn't clear where the automatic assumption came that came to net worth as opposed to say net asset value on per asset basis. Which would be consistent with the prior paragraphs, right? So, you leave out the net value of each particular asset as it may go up or down during the marriage. I wasn't clear where that, thus it was based on net worth came from. The agreement doesn't use the word net worth.
The net worth asset value is how it was stated in the prenuptial agreement.
So net worth does not appear in the prenuptial agreement. It says net asset value.
Right, it's net asset value.
And so what was the basis for saying that means net worth when it doesn't say net worth? There were other plausible meanings of that term other than that.
What would the other plausible meanings be? Because net asset value seems to mean the same thing as net worth.
For instance, net asset value on a per asset basis rather than on an aggregate net worth basis. Net asset value.
I see your point.
Yeah, net asset value is not a common term. It's a set meaning.
I see your point. When in the actual agreement, they call it net equity. They call it net equity in the agreement. So I believe what the intent of the parties was, it was to get back to their net equity that was stated in the agreement, which Kathy's net equity was $1,412,000 and Charles's net equity was $2,341,000.
What paragraph are you referring to? It's 29.
I'm referring, and I was about to say that, I was referring to paragraph 1 and 2 of the prenuptial agreement, in which they set forth their net equity. They put their present value and then their net equity in paragraph 1 and 2.
So net equity and net asset value mean the same thing, that's your position?
That's what I believe that the drafters intended.
Council, if I could ask you as a follow-up, let's assume that setting aside this differing terms, whether we are governed by the terms themselves, the intent of the party, assume we accept your argument that we're governed by the intent of the parties. The intent of the parties is as you're arguing your brief. So if your client were to have failed to pay income taxes due to the IRS, and the IRS put a tax on took it, and the appellee maintained all her assets as they were at the time of inception of this agreement. If we accept your argument, does that mean that we have to take from the appellee's property to equalize from your client, despite the violation of the law that led to?
Well, there's violation of the law for one, but the intent of the agreement is for the parties to be able to live their lives during their marriage without concern for where their assets were going during the marriage, because at the end of the marriage, they were going to be returned to them. That's the whole intent of the agreement.
What if there are no assets?
Then they would not, if there were no assets, then there's nothing to return. So the agreement would fail. But in this case, there was plenty of assets to get them back up to their net equity.
Council, one thing I noticed in your, in looking at how the assets were ultimately disposed of, so I think your client came into it, I think, with 2.4 million net worth, and that was based on representations of values of certain assets in the prenuptial agreement. And ultimately, part of the reason, his net worth, or the value of the assets he came into the marriage went down, was they were sold for less. And it's unclear to me whether they sold for less because they went down in value after he represented the value in the prenuptial agreement, or whether the values were just incorrect when he represented. I'm not saying that was purposeful, but the values that he stated in the prenuptial agreement were incorrect. Without knowing what the true values were, because I don't see kind of a reps and warranty in the agreement. They both say we rep and warranty and guarantee that the values we're representing are true. There's nothing like that I see. And so without knowing the true value of the assets, I don't know whether his net worth actually. I know they valued the assets at the time of trial, but we don't know if the values represented in the agreement were correct. There's no representation that they were. How do you take that into account?
There is a representation about what the values are, and they're stated clearly in the agreement that they agreed on the values, and they signed, the wife and husband signed the agreement stating that these are the values they were accepting. This was to avoid future litigation, and instead this court went back behind the agreement and revalued the assets.
They stated the value of the assets. There was no guarantee. There was no hey, both sides, you kind of like you have a reps and warranties in a business contract, right? But I represent that these values are correct, and I'm in breach of the agreement if it turns out that my representation is not correct. There was no guarantee of those values. So if we take your position that it's, that net asset value means net worth, even though the word net worth doesn't appear in that paragraph or anywhere in the agreement, how do we even know that the net worth went down without knowing the values at the time of the agreement, represented values when the agreement was entered into were correct?
Because the parties because the parties accepted the values at the date of the signing of the prenuptial agreement. And because of that, in stating that the net worth was going to be returned, or the net asset value would be returned, you have to use those values. You don't go back and relitigate the issue of what the properties are valued at. Because in signing the agreement, she did get, the wife did guarantee that she would be, that these figures were acceptable to her, that the values were acceptable to her, and it would not be relitigated in the future.
Which paragraph of the agreement contained that guarantee?
Well, it's paragraph 1 and 2, which we just stated, which states their net equity, and that's based on the attachments of the list of properties and their values. So when she signed the agreement stating that these values were acceptable to her, she was locked into, hey, this is what Charles's net equity is, and that's what's going to be returned to him, you know, based on what the assets were at the time of the marriage.
So I'm looking at paragraphs 1 and 2, and it says, paragraph 2 would be your clients, and it says, Charlie represents that his assets have a present value of $3,019,750, and his net equity is approximately $2.341750 million. Where does it say Kathy accepts those values, and where is the guarantee?
Well,
That's paragraph 1 and 2.
She signed the agreement accepting those values.
But the agreement doesn't say she accepts those values. It says Charlie represents those values. So for instance, what if that values had been much higher? What if he said his assets for 10 million, 20 million? You're going to get faith, maybe you believe that. He's just saying that.
There would be
10 million because
I can't hear you, I'm sorry.
my point is, what if he had said that his assets were worth 5 million or 10 million, and maybe completely in good faith, he just really believed that. But it just turned out he was incorrect, right? When he actually sold the assets, they weren't worth 10 million, they were worth 500,000. Are you saying that the wife would have had to return him to the supposed net worth of 10 million, even though he never had a net worth anywhere near that?
Yes, because those are the values that were accepted at the time of the prenuptial agreement, and she was entering into a contract. And this is a contract that she had her attorney draft, and she had the opportunity to have legal advice. And in signing what his net worth was based on those assets that he gave value to, she was accepting it. Else there'd be no point in her signing that agreement.
Counsel, play that out. So he had represented, pretend he had represented that his assets had a net value, net worth of $50 million. Okay, then during the marriage, he sold those assets for $100,000. So now they go into their divorce, right? And $49.9 million of value that they thought were there was not. The trial judge has to divide up the assets. How would the assets have been divided? I think it's just frozen.
I think you're frozen, Bob. Can we stop the timer?
For transparency, we're still trying to reach the attorney at this moment, so please stand by.
We're fine, David. We're handling on this end.
Okay,
Welcome back. Let's proceed with the time, please.
All right.
okay, the bottom line is the wife signed the agreement. There'd be no purpose for her signing the agreement and agreeing to the terms, which the terms included the valuation of the properties.
Council, please answer my question. I know there was some technical.
Okay,
But so he represented his assets in net worth in the agreement of 2.4 million. And it turned out that the assets sold at less than that. Said he had represented the values of 10 million. Okay, and then when he sold them, and when he sold those assets during the marriage, they only netted 100,000. Okay, so now there's a delta of 9.9 million. And there's not anywhere near that amount of assets in the marriage, in the marital estate for the trial judge to distribute. How would the trial judge, under your interpretation of the agreement, have been required to distribute the marital assets?
the trial judge would have attempted to get the parties back to their net equity by,
I want a general answer, I want a specific answer. He represents 10 million, the assets net 100,000. There's a delta of 9.9 million. How are the assets distributed?
well, the asset, this agreement really did not take into account if there was going to be a loss.
Okay, so your proposed interpretation of the agreement doesn't work if they don't have the same aggregate.
If there's a loss greater than the aggregate of the two estates.
Correct. So under your interpretation of the agreement, assuming there was an aggregate loss on the marital estates, the agreement is just impossible to implement.
It is, but that isn't the case we have here because we have enough assets to get the parties back up to their net equity that they had at the time of the signing the agreement. So that is not the case. And she signed the agreement stating that she agreed to by signing the agreement, she agreed to the values that were assessed by the husband. And the whole purpose, the whole intent of the agreement was if these parties enter into the marriage and they manage to accumulate more than what they had to begin with, then they would split evenly the excess of what was over their net worth. And okay, yes, I'd like to reserve the rest of my time for rebuttal, please.
Okay. I believe you may proceed.
Thank you. This is Ruben Dupay on behalf of appellee Kathleen Gallagher. There are essentially two different issues in this appeal, one more general, and that's the one that the court's been discussing so far this morning, and one bit more specific. With regard to the global interpretation and the more general issue, I think there's three principal rules of contract construction that need to be considered that are well established. I don't think there's any law in dispute between the two briefs, and that the trial court followed. One is that a contract should be reconciled in a manner that allows a reasonable interpretation of the document as a whole. And that's the law that the trial court primarily relied upon in ruling on the interpretation of the prenup. The second and third are interrelated. The second would be that if there's a perceived conflict in terms of a contract, more specific terms should be given preference over and prevail over more general terms. And the other is the unimportance of recitals of intent. While recitals of intent are important in showing the intent of the parties in entering the agreement, they defer and they cannot change any operative provision. And I quoted something in my brief that I thought was fun. Operative clauses prevail over the recital clause when there's a discrepancy between the two. I don't believe.
That argument, did you come across this? We have cases where you have cases on the intent, right, and these intent provisions, and I think you're right what they say. You also have cases that your opposing counsel pointed to, that when it says notwithstanding the foregoing, that's a clear, that's clear language that it trumps the other provisions. Do you have any case, because I didn't see any, where those two are together? So you have an intent clause that uses that intent language that, some of the cases say that, should not be considered operative provision. But you have that notwithstanding language in the same paragraph or that, matched up with the intent language. Is there any case in the state of Florida where that's happened?
And not that I've identified. And I would distinguish the case law regarding the notwithstanding, the three cases, all similar fact patterns. It was up two clearly conflicting terms that were both operative terms in two different documents. It was an acceleration clause in a note, an acceleration clause in a mortgage, both operative provisions. It wasn't the contest that we have here where there's one being a recital versus an operative provision.
In any of your cases, were the recitals in the body of the contract mixed in with the operative provisions?
Your Honor, candidly, I did not go into depth looking for case law on that issue that would compare to this case. I just cited it for the rule generally, and I'm not relying on any of that law that regarding those construction principles. I'm not relying on the facts of those cases in any manner.
It's a key issue because if we were to find a paragraph that is not in the whereas clauses, right, that is not where the other intent is expressed in the agreement, but is actually mixed in with the operative provisions, as far as I can tell, we would be the first court in the history of the state of Florida to find that to be an intent provision, whether or not instead of not.
Okay. No, I do not. What I would
Counsel, as a follow-up, looking at paragraph 29, which is in the body of the agreement, is your argument based on what you believe to be an unambiguous way to construe paragraph 29 together, and that where it says, notwithstanding anything to the contrary, the party's intent, etc., as opposed to if the parties had said the parties agree? You think that makes a difference in this case?
Yes. I do think the use of the word intent in that paragraph 29 makes it clearly a recital of intent. And it would be a different application if it had different language.
So is your argument that paragraph 29 doesn't come into play unless the court finds that the other provision or a provision is not?
My argument, Your Honor, is that paragraph 29 is a general statement of intent, and the other provisions, I think based off recollection, 6, 7, and 8 primarily, are how we get there. Those are the specific instructions to meet that general intent. I don't believe there is a conflict between 29 and those other provisions, and paragraph 8 is the most demonstrative of that fact. If I may, paragraph 8 talks about the retirement specifically and carves out a share A and a share B, and the share A is everything the parties had premarital, and share B is everything else. And share A is then given back to the parties, and then share B is split in half. So that paragraph, which is precisely what the trial court did with respect to the retirement assets in the final judgment, it followed paragraph 8 to the T. And I think that's consistent with the concept and the intent of the parties as set forth in 29. It's their intent to get back their net asset value and split the difference or split any growth. And that's what happened with the retirement accounts. The husband's interpretation would require the court to not follow paragraph 8 in order to implement a general term of a recital as opposed to an operative provision.
Counsel, how do you define the term net asset value?
I don't know. I wasn't prepared for that. Admittedly, I pulled out my phone in that question earlier and did a Google search of net asset value. Google seems to indicate it has to do with mutual funds more than anything else. But a net asset value of, the use of the term net applies, you're going to say value minus debts. But when we're just talking about assets, I guess that's in determining the value of each asset, you look at the equity in each asset.
Do you believe that if you look at the exhibits to the contract, that Mike's touched on this, when you look at the exhibits, it uses the term net worth. But then the agreement doesn't use that same term that's used in an exhibit attached to the agreement. Do you think that causes any patent ambiguity in this contract?
I don't know. Perhaps, but neither party, admittedly at trial, neither party presented any ambiguity to the court. The court didn't make any findings of ambiguity. And although that is a very astute point to make in looking at the language, that wasn't an issue that was specifically tried.
Does anyone have an objection if I move on to the cross appeal?
Go ahead.
Counsel, in looking at your cross appeal, do you believe the error that you're asserting in the cross appeal was preserved?
I'm sorry, I missed the finish of that question.
Your cross appeal, was the error preserved?
I believe so. We were asking the court, both parties were asking the court to enforce the specifics of.
So as far as I can tell, the double dipping issue wasn't presented to the trial judge. And it seems to me like you're arguing that the trial judge ended up doing something differently than what you argued as a result of it. So you didn't argue that, but you didn't file. So if it was an error that you didn't argue about, as far as I can tell, there was no motion for hearing filed. And as far as I know, if there is an error presented in the judge's ruling, and this comes to your attention for the first time in the judge's ruling, you are required to file a motion for rehearing in order to preserve the error for appeal.
Okay, my understanding of that rule is that has to do with the lack of factual findings. If you're if you're appealing or challenging that the court failed to make specific factual findings that are required. I did not believe that rule applied to legal error or other error.
You're saying here's the first time on the face of the judgment. You do not need to file a motion for rehearing before you appeal?
I'm not aware of that requirement, no.
So did the trial judge get an opportunity to decide? Was it ever presented to the judge at any time?
The issue presented to the trial judge with respect to that home, the wife's position was that it was not a replacement property under the terms of the settlement agreement because it was purchased first while they still owned the original Chicago apartment that had Charlie's equity in it. So because it wasn't sold and then immediately turned over, it was purchased jointly with a debt. And then eventually the intended marital residence was sold. And then they made that their primary residence. So the wife's position was that the entirety of the Bonita home should be split 50-50 and no carve out be made for either party, just split 50-50. So that was the wife's.
In your appeal, you don't challenge the finding that it was a replacement marital residence. You just challenged how the judge divided up the equity. And as far as I can see, you did not challenge how the judge divided up the equity to the trial judge, to the trial court. Now, I can see your point that, well, that's because we were arguing it wasn't proposed marital residence at all. And we didn't know the judge was going to rule against us on that until he gave us his ruling. But your opportunity then to present that to the judge was, Judge, I know you rejected our argument that this was not the replacement marital residence and it is, but you misallocated the equity in that property. That second part, you misallocated the equity. Your opportunity to present that to the trial court would have been a motion for a hearing and filed. So I guess I'm asking you to answer Judge Wozniak's question, yes or no. Did you or did you not make that argument to the trial court?
You have correctly recited that I made no argument on behalf of the wife to the trial court. There were no motions for rehearing filed by the wife on that issue. And that specific issue, as you correctly pointed out, wasn't made as part of the closing argument because the position was that it wasn't a replacement property. So I'm sorry, I missed the yes or no part of that question if I didn't answer it that way.
Thanks.
So, but to address the motion for rehearing, I'm not aware that the law requires a motion for rehearing on a legal issue to be made on that type of issue. So I don't know that that prevents the wife from making this appeal now. And then just to close the loop on that, the language of the agreement, specifically paragraph 6, once the court found that property to be a replacement, quote unquote, replacement property, any increase in the proposed marital residence shall be allocated equally between the parties, except for debt reduction described in paragraph 5, which didn't apply. So regardless of when we're talking about the increases through, it's an increase, and if there's additional value, it needs to be divided over and above Charlie's equity.
I think there's actually a lot of cases.
I'm sorry, you cut out. I couldn't hear the second part of that.
There would be a lot of cases.
Okay. I still missed anything after cases.
Counsel, with respect to this issue, the language you just read in paragraph 6 says the increase in proposed marital residence. Let's set aside the issue of whether a legal issue has to be. You would agree, though, however, challenge to the lack of factual findings to support the trial court's conclusion, you would agree that has to be raised in the question here, correct?
Yes. If we were challenging a lack of findings, that has to be presented. That's the relatively new rule.
Well, aren't you really challenging the trial court's conclusion that the starting point in terms of increase in proposed marital residence is the $435,000 that you found? That there's no factual basis to support. What does increase in the proposed marital residence mean to you? Increase from what point?
I don't. The court didn't make. The court's limited finding on that issue is found in paragraph 11. The court finds the party's marital home is the husband's non-marital property and that it is his replacement property pursuant to the agreement. The court doesn't make any specific findings in the meat of the final judgment about the values. Those are found in the attached spreadsheet.
Which is incorporated into the judgment.
Thank you. But it does find that the asset is worth $525,000. It is there, that the larger number is there. It divides it 90,000 to be shared, and then the remainder, the $435,000 to the husband's non-marital.
Right. So looking at the trial court's judgment on the face of the judgment, including the attachments incorporated into the judge finds that the non-marital that the equity, which was based on your client's trial testimony of $525,000. So therefore, the increase in the marital residence, since this is the replacement, is $90,000, which is exactly what the agreement says. Unless your challenge is, and that's why I'm asking you, isn't your challenge that there's a lack of factual finding to support the judge's conclusion that the starting, that is your argument, if you fail to preserve that below?
I'm gonna answer that parts. Part one, I would, to characterize what the issue is that was briefed. I briefed it as if it was a challenge to the application of enforcement of the agreement. So I briefed it as a de novo matter of law review. The court applied the contract incorrectly. In the way you're phrasing that question, Your Honor, I'm coming around, you're convincing me. Maybe I was rather challenging the court's factual finding of $90,000 as the increase based on a lack of competent substantial evidence, because the increase should have been the difference between 525 and the 180 Charlie's equity as set forth in the contract. So as I sit here and giving it 30 seconds of thought, I don't know where I'm now weighing, but I do see your point. I appreciate that point. When it comes to the,
If it was a factual finding, period of final, first time the final judgment in your challenge.
I'm sorry, I could,
If it was a factual finding that appeared in the final judgment, first time in your challenge.
right. And so when it comes to the preservation of error issue that you're raising, I guess where I'm hesitating is my understanding of the new rule that motions for rehearing for factual findings have to be made. And it might be my misunderstanding, is that it's because in family law, in any given issue, there's 10 or 15 different factual findings a court has to make. So if you're appealing on the basis of the court failed to make a finding of fact, that is what had to be in the motion for rehearing, as opposed to the rule of if you're challenging a finding of fact that it's not based on competent substantial evidence. I would also point out that this final judgment was issued a year and a half ago. Let me look at the exact date so I'm not speaking. It was issued in July of 2021 when that new rule that we're talking about did not necessarily apply, and the second DCA didn't necessarily preclude appeals for failure to make a motion for rehearing. So I would be, I would respectfully request the court not apply a procedural rule that didn't exist at the time the final judgment was issued to this case.
But counsel, if, again, setting aside whether you're required to file a motion for rehearing, I don't recall an argument in your brief challenging the lack of competent substantial evidence in support. I do recall you law.
I missed about the last sentence, but I heard the preamble to that question, and I would agree. You're correct. I did not challenge any lack of competent substantial evidence. I challenged the application of the contract to the undisputed facts. And there wasn't a big dispute of the facts. We had one expert, setting forth the value of the properties at different times and different intervals, and we didn't challenge. So you're correct. There was no challenge in the brief to lack of competent substantial evidence. And if it seems I'm out of time, so I'll just conclude by asking the court to, on behalf of the appellee, to affirm the trial court's rejection of the husband's proposed interpretation of the prenuptial agreement and reverse the distribution of the parties Bonita Springs home and remand for the entire $345,000 increase to be divided equally. Thank you.
Thank you. Appellants, you have 3 minutes and 48 seconds.
Okay, and importantly, the recital paragraph regarding the division of the assets is stated before the numbered paragraphs. And it says, whereas it is the intent of the parties that if in a divorce subsequent to their marriage were to happen, the net asset value of each party would be returned to that party and any and all excess would be split evenly. That's the recital paragraph. Paragraph 29 is an operative paragraph. It states basically the same thing, but then it goes on to explain how to accomplish the division of the assets. So it is not a recital paragraph. Paragraph 29 is an operative paragraph, and it controls because it has a notwithstanding anything to the contrary herein language. And, you know, this court is correct that I could not find a case where it was applied in under circumstances like this. But when you have the notwithstanding anything to the contrary herein language, that acknowledges that there may be conflicts within the contract itself, and that the notwithstanding anything to the contrary herein controls the overall agreement. So that's, you know, that's very important.
Council, let me ask you the same question I asked. After that language you just read, the notwithstanding, it says the party's intent as opposed to the party's agree. Do you believe that that paragraph only comes into effect if we need to look at the party's intent, i.e. find the contract to be ambiguous?
Well, the whole purpose of the contract is to provide for the party's intent upon dissolution of marriage. And so the intent controls, especially with the notwithstanding anything to the contrary language. It states how they want they agreed on their assets being divided upon the dissolution of marriage.
So is your argument that the paragraph 29 will mean the same thing? Parties said, parties agreed that the economic effect shall be as opposed to the parties' intent.
I'm sorry, I couldn't hear you.
Is your argument that paragraph 29, it says, notwithstanding anything to the contrary herein, the party's intent, etc., that if the parties use the word the parties agree instead of the party's intent, that the meaning would be the same?
Yes. Yes, it is. So, Your Honor, there's no purpose for the recital that I read earlier and for paragraph 29 to be in the agreements unless it was going to be effectuated and the parties agreed to the terms of the contract, which is what they did, which includes the terms of the value of the property. The court improperly went behind the contract and revalued those assets, which it should not have done, to come to the conclusion that of how to divide the property. When there's an operative paragraph in 29 that states how the property should be divided upon the dissolution. So I just ask that this court follow paragraph 29 and reverse.
Thank you, counsel.
Thank you, Your Honors.
And we will move on to the next case. We actually are going to take it. We'll be in recess. Welcome, everyone. We are back in session. I know there are some people here who weren't here before, so I'll go ahead and introduce myself. I'm Judge Carrie Ann, and I'm here with Judge Keith White, also from Orange County, and Judge Joshua Mize, also from Orange County. The next case on our docket is 23-64, Cullen Smith versus Robert Wiles. Counsel, are you ready to proceed?
Yes, sir.
Thank you. Appellant's counsel? And how much time would you like to restore?
5 minutes, please, Your Honor.
Okay.
May it please the court. Daniel Rock here today. I'm counsel for the appellant, Cullen Smith. I'm here with trial counsel Frank McDonald. This case is about a low-speed, low-impact rear-end collision. After a 3-day trial, the jury rendered a defense verdict on the issue of liability and causation. And post-trial, the trial court took away that verdict for 3 reasons. None of those reasons had record support. The first ground for the new trial was related to Mr. Smith's comment about Morgan. During cross-examination, Lyle's counsel asked Smith if he accepted responsibility for causing the impact of the crash. It's important to get the language of this response exactly right. He said, "You know what I think? It's a dual responsibility. I think the cause was him, and I think that he looked at the TV a lot and saw that Morgan doesn't sue people, they sue companies." What the court's trial, the new trial order says about this comment is not supported by the record. First, the order found that Smith said Lyle's spikes because of Morgan acts. That doesn't appear in the transcript. That's not what he said. Second, the order says that the comment was intended to deprive Lyle's character. But that's not supported by the record either. In fact, the court said at the time that it was not intentional.
Would you agree that we're here on an abuse of discretion standard on all 3 of the issues?
To the extent that there are legal questions involved, particularly with respect to the biomechanics testimony, I think that that's more of a de novo review. And there's also some legal questions in the 3rd issue about manifest weight. Generally, it's an abuse of discretion. That's true. But it's important to understand that in this context, what qualifies as an abuse of discretion is set out in the case law. The trial court's required to specifically enumerate in its order the specific reasons why a new trial is important. And the first step is then on appeal to analyze whether or not each of those findings has. The case law says if there is no record support for those findings, then that is by itself an abuse of discretion. So as we're going through each of these points, to the extent the court didn't support its findings, didn't have record support for its findings, then that's the end of the story for each of these points. And so on Smith's comment, the order says that it was intentional, but then right after the comment was made, the trial court said that it wasn't intentional. In fact, the court said that he's been doing this for 30 years. The more we do this, the more we see. I think I'm a pretty good judge when things were planned and when they weren't. And I don't think by any stretch of the imagination, I think Mr. Smith was testifying for certain things. And then plaintiff's counsel at the time said, I'm not impugning anyone. So the record doesn't support finding that this was intentional. And then on the 3rd point that the order makes is that this comment from Mr. Smith actually had the effect of depriving Lyle's right to a fair trial. But it's important to remember that this was an isolated comment, and the court immediately instructed the jury to disregard. And then on the issue of prejudice, the court also gave his opinion. The trial court said, this is just as likely to hurt Smith's case and Smith's credibility. So you have, at the time, the court saying that this was something that cut both ways. That's not the type of comment that would vitiate the plaintiff's right to a fair trial, vitiate the entire trial. And of course, it was never mentioned again. Medina on this point, State Farm v. Medina, is very instructive because that's a case where there was a comment that was even worse than what we have here. There was a heated back and forth for 15 pages of the transcripts in State Farm v. Medina, highlighting this back and forth fight between the defense expert and plaintiff's counsel. And plaintiff's counsel asked, well, don't you have a financial incentive? And then the expert's response was, I'm not a plaintiff's attorney. I don't get my opinions based on money. After a defense verdict in that case, the trial court ordered a new trial. And the fourth DCA reversed because it was an isolated crime. It wasn't a feature. And that's certainly instructive here, where you have a comment that doesn't really even make sense when you read it. And so compared to Medina, in this case, there's clearly no prejudice from Smith's.
And there were also comments, or I guess more of a dialogue here, you know, law firm, and about personal injury cases and things like that as well. Was that the only time that came up?
Yes, yeah, I think you're referring to the one here about Morgan and Morgan. Yes, and it's important to note that during voir dire, the trial court struck every single juror that Lucas challenged on the basis of bias. So this was not a feature of trial. This did not come up again. There was a brief comment, a brief question from the jury about Morgan and Morgan, but the court didn't ask the question and specifically told the jury when they submitted the question that it was not admissible. So this is something that did not become a feature of the trial.
What about the question that one of the jurors asked, I think?
Yes.
When plaintiff's law firm was retained, and how does that play into?
That doesn't move the needle here, I don't think, because not only did the court not ask that question, but the court also instructed the jury at the time that the question was inadmissible.
Did it show that the juror was could be?
I don't think that we can say that, Your Honor. And I think it's also important to note that the comment in question that allegedly caused prejudice here, we have the trial court's initial thought. We have the trial court's evaluation of any alleged prejudice. And the trial court said immediately after the comment that this is just as likely to hurt the defense as it is to hurt the plaintiff.
Is there any case that says an initial comment like that from the trial judge is binding, the judge can change his mind? Part of the reason we defer the trial judge is the trial judge is sitting in the courtroom. He or she sees the jury, sees the looks in their faces, sees whether they're inflamed, right? So there's something the trial judge sees that we can't possibly see in the transcript. So, you know, if the trial judge makes that comment and then looks over to the jury and starts seeing their reaction, that's not going to come through in the transcript, but it's one of the reasons we defer to them. So is there, you focus a lot in your brief on that initial reaction from the trial judge. Is there any authority that says we should place any weight on that initial reaction?
Well, I don't think that it's binding in the sense that you're asking about, but I think that it's very important for the reason we just gave, because the trial judge sitting there when the comment was made had the ability to see the courtroom, see the jury. And after that, the trial court's reaction was that this cuts both ways.
So the comment is made, counsel approached the trial judge reserved, you know, ruling on that at that time while the counsel were approaching a sidebar.
Yes.
And then makes the initial comment that he did. Then presumably the trial counsel goes back to the dais and starts asking questions again, right? At that point, trial judge looks up, sees the jury, right? So you're kind of saying that the trial judge, we should look at the trial judge's comments at that exact moment because he can see the jury, but not the next, you know, however many hours or days of trial when he's looking at the jury, including the moments after he made the comment. He would have started again, and the jury would have refocused its attention. Well, there's a lot going on that we don't see, and the reason I'm asking is because you place a lot of emphasis in your brief on what the trial judge said, what the trial judge said. I just don't see any authority that we should place any weight on this comment from the trial judge.
Well, I think the frame of reference here again has to be whether or not the order that the court entered has reference. Because ultimately the trial court's new trial order has to have reference support. So what do we have in the record? What can we look at in the record to evaluate whether the trial court's statement that there was a prejudice that deprived the fair trial is accurate? And when we look at the record, we don't have any of that evidence. The only evidence that we have is that the trial court at the time said that this was just as likely to hurt the defense as it was to hurt the plaintiff. So if evaluated from the standard of review, I think that the first step is the statement in the order supported? What can we point to support it? And the only thing that we can point to is not supported. So that's the first of the three grounds, Smith's comments. The next ground that the court relied on in granting the new trial was Dr. Scott's comment during his direct testimony. Dr. Scott was Smith's biomechanic at trial, and he played a video showing how an occupant moved in a more severe crash. And then he said that the occupant was uninjured. The trial court, in its new trial order, says that violated the prohibition from Dr. Scott finding medical evidence. But there's no record support for that finding for three reasons. First, this is not a medical causation opinion. Florida law says what a medical causation opinion is. In fact, the very case that the court relied upon, Maines v. Fox, specifically says that medical opinions require an evaluation of the patient's specific history, and the particulars related to the specific person, which go beyond the typical expertise of a biomechanical engineer. Dr. Scott's comment about the occupant in the vehicle never mentioned Lyle's injuries. And the flip side of that is Dr. Scott's comment was entirely permissible under Florida law. Biomechanical testimony, again, is laid out and defined in Maines, the same court case that the court relied on. Maines says, quote, the biomechanical testify about when the forces involved in the accident would not generally cause the type of injury suffered. So there's not this, in the answer brief, plaintiffs say that the court prohibited all causation testimony, all injury causation testimony. But we have here, from the case that the court relied on, a direct statement that biomechanics are allowed to testify on injury causation. And they're allowed to testify that and create the inference that the forces in the crash could not have caused injury. And that's the case law, but we also have instances where the trial court also permitted this. For example, the trial court specifically said that Dr. Scott was allowed to compare the accident forces in the crash to other activities that don't cause injury. And this is really important to understand. Immediately after Dr. Scott said that the occupant was uninjured, there was an objection. Then, of course, the testimony continued. The next question, the very next question, asked about whether or not Dr. Scott could relate these forces to activities that don't cause injury. And he said this would be slightly more force than somebody would feel if they were lying. Dr. Scott said that the forces on Lyle's head would be similar to what someone would feel if they were falling backwards. Why is that relevant? It's relevant because it specifically shows that the forces in the crash were generally insufficient to cause injury. That's the point of biomechanical testimony. And when you look at Boyles v. Dillard out of the first DCA, they say that that's the point of biomechanical testimony.
Counsel, were there other reasons that the trial court could have specifically had a problem with this question? So you take the person in the video, right? They're a professional, they do those videos. They're different, right? They might be in a different level of shape. They're expecting to crash, so they might brace themselves. There's all kinds of reasons where the person in that video is not in a comparable position to a person who's in a crash and is not expecting to be hit. Are there a lot of other reasons a trial judge could find that specific question was that person would be more prejudicial than probative, given that that person is just not situated in the same position as the person who gets hit, not knowing they're going to be hit, who's not a professional accident recreator?
Well, I have two responses. First, I think that that's fair for cross. I think that that's then something.
But the trial judge has to do a 403 analysis, right? There are certain things that don't come in, notwithstanding the ability to cross, because the trial judge says that's too prejudicial. And what I'm telling you is, if the judge had just said, I think this is prejudicial because the jury's going to hear that person is not hurt, they're going to think that the plaintiff in this case could have been hurt. But that person is a professional, right? They prepare themselves physically for these. They know the crash is coming. right? They felt the force of force, they might not brace themselves, whatever the trial judge thought. Would it have been within the trial judge's discretion to say, I think that question is more prejudicial than probative, don't ask?
I think that that would be a very different record if the court did ask that question, but that gets into an important point here. The order says exactly why the court ordered a new trial. And it says it was because Dr. Scott's comment was a medical causation. And the Tipsy Coachman doctrine doesn't apply to new trial orders. Jones v. Atkinson makes that point. So we can't provide an alternative reason to support the new trial. Theoretically, the court maybe could have performed a 403 analysis and gave its opinion about whether or not the prejudice outweighed the probative value, but it didn't do that. And so the order as it stands is not supported by the record because this was, in fact, biomechanical testimony. I see I'm going into my rebuttal. Can I still? Thank you, Your Honor. So on the issue of prejudice with biomechanical testimony, we have a very important concession actually in the applicant's answer brief, where they specifically say that Dr. Scott was allowed to say the force in this crash would only cause injury. So that plays right into our argument that there can't be prejudice here because it wasn't that cumulative testimony. It was cumulative of the analogies that we had just talked about a minute ago. So the court's finding that this was incurably prejudicial is not supported by the record. And then very briefly on the last ground for the new trial, its manifest weight findings. It's important to remember here that we have two different findings as to liability and causation. And under the case law in Mayers, the court has to be correct about its manifest weight ruling on both grounds in order for this court to affirm. And as to liability, the two findings that the court made are simply an endorsement in this case. The court said that Smith didn't provide any reason for why he didn't stop. Transcript says the exact opposite. And on causation, the court was focused on the issue of whether or not Lyles should have been entitled to recover for his emergency room visit. But in fact, an accident doesn't make you liable for emergency room costs, particularly where, as here, you have a lot of evidence of pre-existing conditions and conflicting medical causation testimony. And again, that's Mayers and Schatz. So because none of the trial court's reasons were we respectfully request that this court reverse and demand instructions to reinstate.
Court is Brian Lee, represents the already hit a couple of points that I'm going to the premise. I think that you goes down starts from the beginning is that all of the issues were here. There's a reason for that. Is because when the trial court is looking at a plaintiff's motion for a new trial, especially granting, one of the things that courts such as yourself have told trial courts to do is look at everything. Not just to look at isolation, but look at the entire trial, the entire breadth of what happened to determine whether comments that may, at the time, a court at the spur of the moment said, didn't think was intentional, maybe those were intentional. Trial courts can certainly change their mind. And so when you look at this record, all of the arguments that appellant brings falls away when that comes under scrutiny, because the trial court absolutely looked at the breadth of that. There's nothing in this order that you are looking at that's matter of fact, we talked about it. And so when we look at the particular parts of this order, the parts are a sum of the whole. And the trial court in multiple fashions in this order talked about how these things individually, but also cumulatively led to my client not getting a fair trial.
Counsel, what do we do with the fact that in the trial judge's order granting a new trial, after we looked at the trial, he described the plaintiff's comment or the defendant's comment inaccurate? I mean, the way that the trial judge described the comment in the order is just absolutely incorrect. It's not accurate. It doesn't comply. It doesn't comport with the transcript. You know, the defendant did not say the plaintiff saw because he stopped because he saw Morgan, doesn't it? And it's an abuse of discretion standard, but it does have to be facts in the record to support that exercise of discretion. And the fact that the trial judge said that he was relying on did not exist. It's completely belied by the transcript.
So one thing I would push back somewhat on that is that the context of that comment when it came in from the defendant was that the defendant had talked in his testimony about this quote spike stop. And it was very clear in the testimony that this spike stop, at least the defendant's perspective, was something that was not warranted at all. And it was somewhat of almost a pejorative, that he just stopped without warning. And so when we get to the point where he's making this comment, which the trial court judge said just came off the top of his head, but he was saying specifically, there's two people at fault here. There is my client, person who was front, who did a stop that he shouldn't have, and then lawyers. Now he jumbled that up into two different things. Did he?
But you just agreed with me, right? There were two different things, and that is, you know, the defendant said, you know, he stopped inappropriately, and then he saw these ads and decided to sue. He did not say, what the trial judge said is that he stopped because he saw Morgan ads. That was not said at any time during the trial.
I would agree with that.
So you agree the trial judge's order is based on a comment that was not made?
I would agree that it's based upon, it's a comment that was made, but the interpretation of that comment, I believe, was not what actually happened. The trial judge was saying that he said he stopped because he saw Morgan Adams said, I'm going to stop because of Morgan Adams. That's not what the trial
Okay, so the fact that the judge relied on is not in the record. Didn't happen. The cases say that the judge has, that we have to respect the judge's discretion, and it's an abuse of discretion standard, but it must be supported by facts in the record. The fact he cited is not in the record and is contradicted by the record.
But I don't think that's the only finding that was in this order about that. And I'm looking specific. So he does say, trial judge absolutely says that within the body, the first paragraph of that. But then when we get to the order part, what he's adjudging, I guess, is paragraph 1. When he talks about Smith's comments, he says he made improper remarks, outbursts, and conducted himself in an improper way. And its effect on the jury cannot be cured. The remarks and conduct of Mr. Smith were made.
He's describing a comment. He says at the beginning of the order the comment happened. Later on, he's describing the comment that did not happen. But you conceded that. The comment he based his order on did not occur. So what does it matter how the trial judge described that comment if the comment was non-existent?
Because it's the effect of the comment. The comment was made.
So if the trial judge, what if the comment had been even more wrong, right? What if the trial judge just thought he heard something that was completely wrong, or it's too far away, or whatever? Like, how different does the trial judge's view of the comment have to be before we don't accept the trial judge's description of the effect of that comment, right? Like, you're basically saying, well, he's describing the effect of the comment. How can the trial judge evaluate the effect of the comment if he's patently wrong about the content of the comment?
Well, I think the case law talks about when you have a situation where the trial court, there was a comment that was made that the trial court said, I'm just throwing this out, you know, the light was green and the person said the light was red. That is an actual, it didn't happen. You know, he was exactly wrong about the comment, so that was not said. Okay. We know that the comment was said in this case. It is the trial court's interpretation of that.
No, counsel, what you're saying is not. It's not just how the judge perceived the effect of the comment. He says in the order what the comment was, and he describes it inaccurately. The comment he says occurred did not occur, and you've conceded it did not occur, which you had to because it didn't occur. Obviously, you had to concede that. So this is not him looking at some, you know, having discretion about evaluating the effect of the comment, because he's evaluating the effect of something that absolutely did not occur.
I think he's a.
What if he thought he heard the defendant call the plaintiff a bad name, right, under his breath? And he was just wrong, right? It was a completely different word. Nobody else thought that word was said, but he just heard wrong for a second, thought that the defendant made some, called the plaintiff a bad name. Would we just say, well, he's evaluating the effect of that, even though the name didn't occur, we have to defer to his evaluation of the effect of the comment, and the comment didn't occur.
I think, I think that should have to be yes, because when you look
So the
at.
trial judge imagines a comment
No,
did
I'm
not
saying
occur
that.
at all. And we have to defer to his evaluation of the effect of the imaginary comment.
No, I'm not saying that if the trial judge said something happened and it absolutely did not.
Okay, but you conceded, the comment he said happened here absolutely did not happen.
I'm conceding that the part where he said that he spiked up because he seen that wasn't even said.
Correct.
I'm not saying that there was
Comment on
a-
which he based it.
That's one comment that he based his order. There are certainly other bases of his order.
Okay, but in terms of the defendant's comments, we'll get into the expert
Sure.
testimony. In terms of the defendant's comments, that is what he based his order, correct?
That is.
And you concede did not happen at all.
He didn't say it like the trial court said it said.
Did he say the comment the trial court said?
He said, he did not say that he spiced out because he'd seen advertisements. Did not say that.
So what the trial judge said happened, didn't happen, yes or no?
That's yes.
Okay.
So when we get, so then let's go to the second one because I know I'm running out of love.
Counsel, Mike, to
Yes.
follow up on that.
Yes.
As I was reading your argument, does your argument take into account that there's a rule which requires the judge to get a specific?
It does.
And so this isn't a circumstance where you have a judge or a jury make some finding. For example, where there's no statutory specific findings. It's, and the evidence, any construction of the evidence support the verdict.
Right.
And that clearly seems to be what you're arguing. I appreciate that. But is that standard applicable here, where you have the requirement of specific ground must be set forth? Cases interpreting that rule, don't they indicate that, well, you don't just look to see is there anything that could support the granting of the trial? Isn't our standard, is there evidence in the record to support the specific grounds?
Sure. And I think I agree with that. I think the way that I see and interpret it is that when you are looking at a motion for a trial in a specific, it's one thing to say that the defendant said this, and the trial court clearly put in his first paragraph that he was at Baldwin Spike Stop because he'd seen advertisements. That's what he put. It's another thing for the trial court to then use that comment and say, I believe that this comment caused prejudice to the plaintiff and due sympathy from the jury or all the things that the trial court put in. Because I don't believe that you can look at if the trial court would have said that in the body of the text later on that said, I believe that saying that you've seen advertisements from Morgan & Morgan is against the law, and you can't do that, it's illegal, and therefore that's the reason. What the trial court said was that he said this comment, me as a trial court, I think said this, and I think the comment caused prejudice. So there is some divorcing I think you have to do.
Counsel, how divorced do you get if the prejudice the trial judge is observing is coming from something that didn't exist? Go to my hypothetical, right? And
Sure.
I think what the premise underlying your response is that, well, they were kind of a similar subject matter, and he's, even though he got the comment wrong, he's perceiving the prejudice. How wrong does the trial judge's, finding of the comment have to be? So take my hypothetical. Trial judge thinks he hears the defendant call the plaintiff a bad name, right? It's inflammatory, it was wrong, he shouldn't have. Turns out trial judge just heard wrong. It was a completely different word. Nobody else heard it that way. the comment didn't exist at all, nothing even close to it, not the same subject matter, didn't call the plaintiff a bad name. But the trial judge says, well, I perceived prejudice from what I think I heard. I don't think any lawyer would get up here and tell us, well, you have to refer to the judge's finding of prejudice about something that's completely contrary. So here, you've acceded, we have the trial judge relying on a comment that did not happen, doesn't appear in the record. But you're telling us, defer to the finding of prejudice anyways about something that you conceded did not happen. So is the underlying argument just that, well, it was close enough to what happened?
I think my argument at the end of the day is that the comment, regardless of what you believe it was, and the trial court got completely wrong, the comment itself was prejudicial. And so when he put the comment, he specifically said, I'm finding that comment is prejudicial. He's finding it for a variety of reasons, because he talks about them within the order. And so I don't believe, and to answer your question, effective directory, it's not, it's your job, because the abuse of discretion standard, I think is something that appellate courts grapple with. You know, in your situation, in cases that we've both seen, where the comment absolutely did not have any close to it, the court has said, that's not a specific ground, and therefore I can't do it. In cases that are what I believe are more closer questions like this, where the wording was not there, but in my view, the trial court said the sentiment was there, that's where I think the appellate court has to make it.
So you're saying our review should turn on when the trial judge faces a new trial on a comment that didn't happen, our review should turn on how far off or how wrong the trial judge was in hearing the comment.
I think that, I guess.
The more incorrect the judge is, the farther off he is in perceiving the comment, even though either one is incorrect, the less deference we should give.
I think perception is important in the analysis. I think perceiving because the underlying premise is what reasonable persons, if reasonable persons would not have done what the trial court did.
But all types of reasonable people just mishear things. That doesn't make anybody misreasonable, you just mishear something. That doesn't make the trial judge unreasonable, but it does mean he perceives something that just did not exist. We wouldn't call him unreasonable, but we wouldn't pretend to think that.
I would agree with that. I just think that there is a sliding scale.
Even if we assume that the comment was prejudicial, how come what happened at trial wasn't enough? It was a defendant who said this, it wasn't an attorney. The defendant was probably upset about being sued. The trial judge said, Mr. Smith, this is not what the case is about. Listen to the questions carefully. You admonished, it's there at the time. Weeded out jurors during voir dire that preconceived notion about questions. How come that was not enough to overcome whatever prejudice?
Is that they had to look at the continuum of the trial, what happened. There were multiple people that expressed very strong feelings. We're going to use these. They were sure. That is true. But to say that those comments, the jury that were in that case heard the comments from others. And we know that it was on the jury's mind, or at least one.
Have you raised any of the other comments made during voir dire?
No, because we're not going to.
Are you permitted to argue that?
The comment, from the, I'm just responding to what the appellant said. I frankly think that the part that hits home, at least for me, is when the plaintiff was testifying and the jury had a question. When did you hire Morgan? Totally improper, but the jury had that question. That was it. And so with that basis, for then the defendant to come up and talk about Morgan and Morgan is not, in my mind, coincidence. But it certainly shows why that comment, even though it's one comment by a defendant, when taken as a whole, was prejudicial to my mind.
Counsel, in your brief, you distinguished the Medina versus State Farm case by saying that the witness's comment in Medina, was elicited by badgering from the plaintiff's lawyer. Okay, and in our case, that didn't happen. How would that have any effect? Because we're supposed to think about the effect on the jury, whether or not you receive a fair trial, not on the witness in terms of badgering.
Right.
So how does the fact that the comment in Medina came about through some tense exchange with the plaintiff's lawyer and the witness, how does that have anything to do with the effect of the comment on the jury's ability to be informed?
Because the Medina court also said, and it really found at the end of that analysis, is that the plaintiff attorney, the attorney who was asking those questions, invited them.
But again,
Through the question.
how the comment was invited to do with the comment's effect on the jury? What we're supposed to be evaluating is the effect on the jury, right? Your client's ability to receive a fair trial. How the comment came about or what elicited have any connection to the effect of the comment on the jury?
I think Medina talked about that and talked about that's why it would be an abuse of discretion. Because when you're talking about it, I think that at least the Medina court was.
So the Medina court found that the trial judge abused his discretion, right? And the trial judge in that case didn't give a curative instruction. Here you had a curative instruction. So the differences I can see in Medina is here you got a curative instruction. They didn't. And you said that, well, Medina is different because in Medina, the witness was badgered by the plaintiff's lawyer. Okay? And I don't see how the badgering by the plaintiff's lawyer has anything to do with the effect the comment would have on the jury, which is the issue. The comment itself either does or does not have an effect. How the comment was elicited have any connection to its effect on the jury? That's how you distinguish the case.
Yeah, frankly, Judge, I would tend to agree with that. The comment is what you have. I mean, it's prejudicial, right? Medina talked about it in the sense of almost excusing the comment, right? Because it was done of this back and forth. I don't think there's an excuse for the comment. And so I think that this comment was inexcusable. And when the trial court made its decision, that's what he said. With my time, I just wanted to touch on one thing with Dr. Scott's testimony. I think the context again is critical with that. Dr. Scott, when he was talking about the forces, he had just talked about the plaintiff's Delta V of the vehicle, had given the number, I think it was 3. And then the video shown, whereas he testifies that Delta V is 5. And then the question is then asked, was the occupant hurt? And he says very clearly no. The arguments from their side is that, well, that's not really a causation. I being with this theory. Why? Because when he's saying, one of the things that the trial court specifically said is you could not do causation opinions and you could not do opinions that would establish a threshold for injury.
Counsel, the trial court said you couldn't do 2 things. Okay. It says the expert couldn't testify that significantly higher forces, the ones in the accident, would be necessary to cause Lyle's specific injuries.
Right.
Okay, the comment made by the expert did not concern Lyle's specific injuries. The second thing that the judge said that the expert couldn't testify to was only an extremely fragile person could sustain an injury similar to what Lyle sustained in his accident. The expert's comment didn't do that either.
I think that I would disagree on the first one.
Because
he said
this comment did pertain to Lyle's specific injuries?
I did.
Even though it was about a person in a video that was not Lyle's?
Yes, I think it was a backdoor way of bringing it in. I think by saying that Lyle's was subjected to 3 Delta V of force, and then bringing a video in and saying this person was subjected to 5 Delta V of force, and he wasn't injured. That correlation is not by accident.
So there's law cited in the appellant's brief saying that medical causation opinions have to be specific to the plaintiff. Is any of that law wrong?
I don't think it is, but
Okay, so this comment concerns somebody who was not the plaintiff. And you're saying it is a medical causation opinion?
I do, because
But you just told me medical causation opinions have to be specific to the plaintiff.
no, but you're talking about May's case, and it talks about medical causation means specific to the plaintiff, meaning if you're going to make medical causation opinions, you have to do those things. You have to look at the medical records. That's why the doctor, I think, was old and Maine was able to make that opinion. I'm saying that the medical causation, to be able to do that kind of opinion, you have to do those things. This doctor did not do those. He couldn't do those.
But counsel, he didn't use the term causation. He just asked, was this person injured, correct?
He did.
Dr. Scott was present at the scene of this test.
I don't know that for sure, Judge. I'll go with your memory. But I'm not sure. It was.
So that an emergency responder comes to, let's just say, a person witnesses a traffic accident, says, I saw a head-on collision. He goes to driver with the vehicle. And question is asked, was the person injured? If they say yes, expert opinion.
If you're then using that opinion to extrapolate that the plaintiff in the case was not injured, it is.
I'm not asking how it would be argued. I'm just asking that test. The expert test.
I'm putting myself to the specific record. There's a lot of things that were said that why that testimony shouldn't fit in anyways, of why it's irrelevant. To say that one, I think if you put in isolation and said that this person was not injured, I don't think there is a difference.
Did anyone do that, counsel? Is there anywhere in the transcript where any person said the person in the video wasn't injured and therefore Lyles wasn't injured?
I don't believe so. That's all my time, Your Honor. I would ask that the court affirms the granted the show. Thank you.
Thank you, and Mr. Rock, I will give you an extra 3 minutes and 43 seconds if you need it, just to make sure we're working.
Thank you, Your Honor. So I would start with Judge White here. I think you're absolutely right that there's a rule involved in this case. And when you're evaluating whether or not to reverse, you have to look at 1.530 where it says and you don't, this is in the way I see this, it's sort of like a threshold question. Before you evaluate whether or not there is something discretionary about what the court did, the first step is, are the words on the page of the order actually supported by the record? And that's what we're saying is unsupported here. The findings that the court made in this order. On the issue of Medina, I think that to answer your question, Judge Mize, I think that the badgering actually makes Medina more persuasive when you think about it. Because if you have 15 pages of heated back and forth between the defense expert and the plaintiff's counsel, that's becoming a feature of trial. You're then creating something of a spectrum, this heated argumentative back and forth. And in the peak of that is when the defense expert made the comment in that case about not being a plaintiff's attorney and not basing their opinions on money. So it actually makes Medina more persuasive when applied to this case. And then the final point that I want to make about Dr. Scott's comments is when you're thinking about biomechanical testimony, there are two sides to this. The first side is, was this a medical causation opinion? I think that it absolutely wasn't based on reasons. The second question is, well, okay, was it permissible? Independently, was this permissible? And it was permissible testimony because biomechanics are specifically allowed to testify on general causation. And I'm going to read straight from the opinion in Maines. That again was the basis for the court's ruling. Quote, it is undisputed that biomechanical opinions as to the general causation of the type of injury are admissible, end quote. So ultimately, any inference that forces, generally speaking, are not sufficient to cause injury are actually permitted under the case law. So whether you're looking at the court's specific ruling or you're looking at whether or not the case law permitted Dr. Scott's statement, both did. And in conclusion, Your Honors, we were able to
back to recall Appellee in the brief citing case law that indicates that if we can't discern from the record the nature of an outburst by a witness. So, for example, how emotional, even tone doesn't come across in the transcript. If you're in a courtroom, you know tone comes across. We don't. I don't. And he said what he said. Setting aside the discrepancy on what the court said he said and what the record showed, looking at the record show, are we still required to reverse even if it could have been the most vehement, hateful, spraying saliva all over the courtroom type? Because we don't know that, do we?
I think we do have some indication actually, because the court said at the time what his view on prejudice was. If it were, this isn't a situation, for example, one of the cases that they cite talks about a witness breaking down on the stand and crying, or having to clear the courtroom and restart the proceedings because there was some kind of an emotional outburst. That's not what happened here. And
How do we know that?
well, because we know what the court said.
But the trial judge made that comment during the sidebar, right? So question is answered, lawyers approach, they speak privately, presumably the judge is focusing on the lawyers. Lawyers go back to their desks, the lawyer asking the question, defense counsel goes back to the podium to address the witness. Then the judge looks up and sees the jury. We have no idea what the jury looked like.
We do not. We don't have that in the record. But the court also never made any specific finding in its order saying that, when I viewed the jury, I saw that, there were members of the jury that were shaking their head violently as,
Would a court have had an opportunity to say that? Would a trial judge, is there any conceivable reason why a trial judge, once the attorneys went back, is there any conceivable reason why the trial judge would stop and say, hey, I want to make a comment about what I'm doing?
absolutely. Rule 1.530. The trial court is required to put the specific reasoning why it's granting a new trial in its order. And it never made that finding in its order. So the court did have the opportunity, in fact, it had the legal obligation to say that if in fact it was important. If there are no more questions, Your Honor, because the trial court erred and its findings in its new trial court order were all supported by the record, this court reversed and reinstated the verdict. Thank you.
Thank you, counsel, for your argument. It was well argued, but for the same reason.